Hello, my name is Robert Larson. I'm an attorney and I'm also the owner of the Larson Law Office in Mesa, Arizona. I'm licensed as an attorney in the states of Arizona and Utah, and I focus primarily on family law and estate planning. And so in family law, whether I'm helping someone with a divorce with children or just a custody case where the parents aren't married, one of the obvious issues that we have to deal with is the parenting rights that each parent has with regard to their children. And so a lot of times people will say to me that they know Arizona is a mother state, and so the mother's going to have more rights. And I hear that from mothers, from fathers, from other family members like grandparents, etc. And the reality is that's not true. It may have been true decades ago, but Arizona has long considered both parents to be equal parents when it comes to the rights to their children. And so there was, even 15 years ago, some parenting time schedules that were common, where the mother would have more time with the children when they were young, and then the father's time would kind of gradually increase over time and possibly get to 50-50, or maybe not, but that was something that existed even when I was working in this area. But that has been gone for quite a while now, and mostly the courts consider each parent to be equal parents and have equal rights. Now, the law doesn't specifically say that each parent is supposed to have equal time with the children and equal rights with regard to decisions, but it does say two things. There is a statute that says that children have the right to have both parents actively involved with making decisions on their behalf. And it also says that children have the right to have meaningful, continuous, and frequent time with both parents. So it doesn't specifically say that it's starting out 50-50, but the way the courts interpret it is the judges look at it like anything beyond 50% for each parent is taking away from the other parent. So when it comes to time with your children, if they give 51% of the time to the mother, that means the father's time has to be less than 50%, so 51-49 or 60-40, etc. So basically 50% is the maximum they can give to both parents, and so they interpret it to be that 50% is kind of the starting point. And the law also says that those are presumptions that are that it's in the children's best interest to have both parents making decisions for them and to have frequent time with both parents, absent evidence to the contrary. So in other words, there's a rule and then an exception. So in this situation, there's two rules. The first rule is that it's in the best interest of the children to have both parents involved in making decisions for them. And then the second rule is it's in the best interest of the children to have frequent and meaningful time with both parents. And then the exception is if there's evidence to the contrary. Now, what is evidence to the contrary? It could be almost anything. It could be something negative from one parent, such as a lengthy criminal history, domestic violence, child abuse, drug or alcohol addiction. It could be almost anything that would prevent someone from being able to be an adequate parent. It could be just refusal to participate in parenting. So in other words, not being involved when one parent is trying to communicate with the other parent about making decisions about medical care or schools, and the other parent's just ignoring them or responding in ways that are inappropriate. That could be a reason not to give equal rights. It could just be, this is more for parenting time than decision making, it could just be that the parents live too far apart to do 50-50. So sometimes it's just not feasible. It could be the distance, or it could be work schedules. Sometimes it has nothing to do with the fitness of a parent, but just it's not feasible because of other reasons. So if you don't have an exception, generally the courts are going to order that you have joint legal decision making, which means both parents have to be involved in making major decisions for the children, and both parents have to agree before any major decisions can be made. And it generally means that the judges are going to start out with 50-50 parenting time unless there's a good reason not to. And so that's where lawyers come in, and if someone's trying to argue that it shouldn't be 50-50, then that's a situation where you need to have an attorney to be able to help make those arguments and make arguments that are going to make sense to the judge. A lot of times people come in and they represent themselves and they make arguments that are important to them. They'll talk about things that, sorry, I'll let the loud car go by. They argue about things that are important to them and are frustrating to them, but don't necessarily make a difference to the judge. And so that's where you need to have an attorney who understands what arguments are going to be relevant, that a judge would actually take that argument and consider it to be something useful in making their decision. And so it's not impossible to get an order that's not 50-50. It just means that basically you're starting out kind of at that equal rights situation. And if you're trying to get something that's not equal rights, you're the one who really has to prove your case. And I will say also, I think it's harder in Maricopa County than it is in other counties. I think judges in other counties are a little bit more likely to go along with arguments that 50-50 isn't the best compared to Maricopa County. But every case is specific to the facts of that particular case, and then every situation is a little bit unique. So anyway, that's basically the situation. Two misunderstandings that I see a lot. First is that Arizona is a mother state. It's absolutely not. Arizona has very strong laws with regards to equal rights. And two is that it's automatically 50-50. Even though most judges kind of start from there, it's not automatic. You definitely have a chance to prove your case. I've seen it happen successfully many times where people have been able to convince a judge not to do a 50-50 schedule or 50-50 decision making. So anyway, every case is unique. And if you have any questions, feel free to give me a call and I'd be happy to talk to you and answer your questions. Or if you want to just leave a comment, I'll be happy to answer the best I can. If you find this helpful, make sure you like the video and subscribe so that you can get other videos in the future. Thanks.